Welcome back. Let's talk about the elephant in the room, or I'd rather say elephant in the courtroom, judicial appointments. It's been a terse war of words between the Supreme Court Collegium and the union government. The union law minister has delivered repeated blows to the present system of appointment of judges. The present system, where the last and the final word rests with the Supreme Court. It has been criticized for being vague, opaque, and without checks and balances. Before I move further into the debate, I want to tell you a little bit more about the Collegium system. First, what exactly it entails. What exactly are the key pointers as far as this Collegium system is concerned. This is a tussle over judicial appointments that continues. Union Law Minister Mr. Kiren Rijiju has fired repeated shots at the Supreme Court Collegium, arguing that they are not taking up the reform procedure as they are ought to. It has also been said that this is a process where judges are appointing judges and judicial time is being wasted. Centre says that judges are appointing judges, judicial time is wasted, and this time could perhaps be used to do some kind of, perhaps take up more cases which are pending in the courts. The government reminds that NJAC was better, a law that was struck down by the Supreme Court, saying that it's violated the basic structure of the Constitution. Let's talk about what the Supreme Court has said, how the top court has retaliated in its own way. The Supreme Court says that the government has been holding on to the appointments despite Collegium insistence. So if the Supreme Court, despite a rejection from the government, has said, go ahead, that's the word government ought to follow. But there have been delays. Supreme Court Collegium is the final word, at least in the present system, after the second judge's and the third judge's case. The Supreme Court has warned that they are going to pass orders on the judicial side if this process of deliberation between the government and the Collegium fails. Let's move on and talk about other critical aspects. What exactly happens in a case of conflict? If the government and the judges don't agree on something, the Collegium receives the view of the government. Once the name goes from the Collegium towards the government gives its view. Collegium may decide to reassert the name. Once the government says, look, we're not happy with these names, the Supreme Court looks at the reasons, and if they're not convinced, they may say, we want to reassert the name. Government may delay appointments. That's what has been happening. About 16 months on certain appointments. Many months take once the reassertion has happened. That's the bone of contention. Now, what happens, in case of a conflict? That's the broader point. But what is the way forward? What is the criticism of the present Collegium system, and what are the reforms that need to be taken? As I said earlier, it is opaque, closed-door system without any checks and balances. It lacks the transparency that the appointment process of world's largest democracy should really be about. There is lack of any check and balance. There's lack of transparency, the names, how they are decided, what the deliberation procedure really is. All of that are not known. And this buzzword, judges appointing judges, it continues to haunt the top corridors of the Supreme Court and the Collegium. Well, let's take this conversation forward with an eminent panel joining us. We have with us former Law Minister Ashwini Kumar, Senior Lawyer Mr. Vikas Singh, and Senior Advocate Mr. KTS Tulsi. Gentlemen, thank you so much for joining us on the broadcast. Mr. Ashwini Kumar, coming to you first, what is the problematic issue, talking about the present discourse, between the Supreme Court Collegium and the government of the day? We agree that the system needs reform, but this back and forth and the kind of war of words that we have seen is indeed very worrying.
Present Collegium system has not really produced the best results. Its record is a mixed record. The problematic issue here is the tone and temper of the debate. That has changed. The kind of insinuation against the judiciary, against the Supreme Court, that one hears in the statements of the equally important constitutional functionaries is not a healthy sign either for the independence of the judiciary or for the functioning of parliamentary democracy, which is premised on one single principle: healthy respect for each other by the coordinate organs of the state. So therefore, today, the single most important challenge is to keep the debate within the bounds of civilized political debate. I personally believe that the minority judgment in the NJAC case by Justice Chelameshwar needs to be looked at.
So to put it very simply to you, can the government revisit the present system? Are there any valid points which are being made by the government?
It has made some extremely valid points in political theory and in constitutional law. So if the government wants to revisit the present system, and it is fully within its rights to revisit the system, it must ensure a collegium or a mechanism where the government, while it may have its inputs, but will be such that would ensure the appointment of independent judges who can sustain the confidence of the nation at large and discharge their role as the ultimate guardians of the final arbiters of the constitutional conscience. That's the challenge before the nation today. How to resolve it, only time will tell. How both organs of the state react to what is happening.
Sir, but it boils down to what can the government do after the NJC was struck down. Is there any room for any further legislation by the government?
Well, it is fully within the competence of Parliament to bring in a constitutional amendment to clarify the position. And if, of course, that is what was sought to be done in the first NJC, which was actually the foundation of that was laid when I was the law minister. Now, the government is saying we need to broad base it so that the law minister or the executive and some eminent jurists have a say. Now, the other side contends that what is proposed is a system in which the final say eventually will be that of the government. Now, of course, a lot has changed in the last 4 or 5 decades, but let us not forget that before the second and the third judge's case, the appointments to the judiciary were made exclusively by the government, and they were amongst the finest judges who were appointed to the bench. So to say that the independence of the judiciary is only secure if the judges alone have the exclusive say in the appointment is not a proposition that I am willing to accept unconditionally. Yes, in the light of the recent experiences, there is a fear that if the executive has a final say over the appointment of judges, there could be a possibility of packing the court.
Interesting point that you make there. Mr. Vikas Singh, taking that point forward with you, can the government regulate the collegium system? Can they bring in a law to that effect?
The government can definitely bring in a law to regulate the collegium system, and they will be well advised to do that. But I would rather prefer the collegium system itself reinventing the system, because if they will do it themselves, the scope for government interference, even at the stage of shortlisting candidates, will be minimal. But in spite of my tirade, and I've been saying this for the last 5 years on various public platforms, that I've been also telling the judges privately, and as president of the Supreme Court Bar, I've been also raising this issue, that you must reinvent yourself, otherwise you're getting so much of flack in society, and people also are suddenly, slowly losing faith in your system of appointment of judges. They are not ready to reinvent. They're trying, but the effort so far is very, very, I would say, negligible. And if they don't do so, probably the government will be well advised to bring in a law to regulate the collegium system, where they let the final arbiter of appointment be the collegium, but at least play a role in shortlisting candidates. And then ensure that these shortlisted candidates go through a credible process. So, for instance, what will be a credible process? Credible process will be that every high court definitely has very eminent lawyers in its fold. There is a president of the bar in every high court. There is a president of the bar in the Supreme Court. So you can involve some of the eminent lawyers. You can involve the president of the bar only to find out, only for the views. I'm not saying that is binding upon you, but at least get all the names collected by some independent, transparent process.
So when it comes to the administration of the Supreme Court, just digressing a bit, listing of cases, what has been the biggest takeaway? Because this is one issue you've repeatedly spoken about.
Well, the biggest takeaway of this year has been that the Supreme Court, which according to me was literally in some kind of a suspended animation since the time of Justice Bobde and Justice Ramanna, because hardly matters were getting listed, and it was impossible to mention matters and impossible to ensure that there is a transparent process of listing. So a change in the guard by Justice Lalit coming in was a very welcome change, and at least the Supreme Court started throbbing again. I mean, the matters started getting listed. Matters filed 2 years before, I'm unheard of in Supreme Court, were lying, waiting clearance at the registry level and not getting listed. Whereas in this court, I've been practicing in this court for 32 years. Any matter which is filed gets listed within a week or maximum 10 days. So whether it be a PIL, whether it be a SLP, whether it be a civil appeal, it has to be listed within 7 or 12 days and in a non-discriminatory basis. Now, these matters were not getting listed, and that was a huge sense of despair amongst the lawyers and the litigants, because you just appreciate the trauma of a litigant, that he has filed a petition, he's awaiting a hearing, and the hearing is not happening.
Absolutely.
So that was a very, very welcome change which came during Lalit's tenure, and we saw matters getting listed, and it is continuing in Justice Chandrachu's tenure.
Mr. Tulsi, I'll give you the final word. You're a veteran. You have seen this court for so long. We definitely need a constructive dialogue. But what is the way forward?
I don't know. At the moment, they have opened too many fronts.
Yeah.
The central government seems to be now even talking about all kinds of things, that independence of judiciary, separation of powers, and 5-2 and 6-6, which were considered, they were declared ultra vires, the Constitution of India. They say that this is basic structure. Now, I don't know in what manner and how long it will take, but the nation cannot wait, and judiciary cannot be seen to be what is being described by the law minister. That's not how matters are going to get resolved. They will be resolved only when they will try to at least find out what is the viewpoint of the other party. That is the court. And the court must also understand that there can be larger consultation. The consultation need not be restricted only to judges.
Sure.
And then only, you see, between the two extremes, the truth lies somewhere in the middle. And they should try to get closer to the middle rather than to the edge on either side.
Well, sir, here's hoping for a far more constructive dialogue between the judiciary and the Supreme Court Collegium. Thank you, gentlemen, for joining us on the broadcast. Well, that was 2020 for you in a nutshell. For the Indian judiciary, an exciting year awaits us as crucial hearings, sensitive issues are all set to be heard by the Supreme Court and also the High Court. Looking forward to those fascinating debates. Thanks for tuning in.